the PSP module of Edukemy. Today is our discussion on the preamble. Now, this is one area in prelims where if you develop conceptual clarity, it will be very easy for you to deal with the questions that are asked in the exam. Also, questions related to the preamble are often interlinked with other areas of polity like fundamental rights and DPSP. So let us begin with our lecture today. What I've done is I've put here some previous year questions for you to take a look at so that we can get an idea of the kind of questions that are asked in the examination. If you look at this question, it is asking us about what the preamble to the Constitution of India is, whether the preamble is a part of the Constitution, and if the preamble has any legal effect. On the basis of just these two aspects as to whether the preamble is a part of the Constitution and whether it has a legal effect, we have been given here 4 options. This dimension will become very clear to you when we discuss the various Supreme Court verdicts related to the preamble. Next question. This is related to the separation of judiciary from the executive. And in which part of the Constitution do we find this principle? See, to answer a question like this, it is very important that we be well versed with the text of the preamble. If you know the text of the preamble, this kind of a question is going to be a low-hanging fruit for you and you can easily ensure 2 marks for yourself. This is a very interesting question that appeared in the 2020 prelims, where the Universal Declaration of Human Rights was asked in relation to the different provisions of the Constitution like fundamental rights, preamble, DPSP, fundamental duties. So here you have to draw upon some knowledge of world history, and again you need to be well aware of the bare text of these various aspects of the Constitution. Another question related to economic justice. And where do we find the principle of economic justice in our Constitution? Again, you have 4 options here. If you see, these kind of questions can be answered if you know the very text of the preamble and you also know how the preamble is linked to the other parts of the Constitution like the fundamental rights and the DPSP. So what is the nature of the questions that are being asked in the exam? We find that there are 2 kinds of questions that are being asked. One is the analytical type of questions and the other is the factual type of questions. Now, what do we understand when we say that the questions are of analytical nature? So, we cannot find the verbatim statements in any of our standard textbooks like Lakshmikant or in our NCRTs. But we can answer these questions if we have some understanding of the preamble and the important Supreme Court cases related to it. For example, the first question that I showed you as to whether the preamble is a part of the Constitution and if it has a legal effect is a kind of analytical question where the text of the preamble needs to be read with important Supreme Court judgments. Second type of questions that are being asked are factual in nature. To answer these kind of questions, you have to interlink the ideas of the preamble with fundamental rights and DPSP, and usually these are easy if you can remember the various words that are provided in the preamble and you are clear about the meanings associated with those words. So now we're going to begin with what the preamble is all about. The preamble is telling us that it is the philosophy of the Constitution. One way to think of the preamble is when you have a new book and the first thing that we notice in a book is the preface or the introduction. Just like the preface of a book or the introduction to a book gives us an idea of the essence of that book, similarly, the preamble enables us to understand the essence of the Indian Constitution. So here, what are the things that the preamble tells us? We will discuss about the importance and utility of the preamble. We will understand the objective of the preamble. And most importantly, we will look at the important key words that are mentioned in the preamble. As I already explained, that the preamble is like an introduction or preface to the Constitution. Also, it has been described as the identity card of the Constitution. Some of these phrases are actually quite important because if in the exam you're asked a question on which of the following has been described as the identity card of the Constitution, and the options include the preamble, the fundamental rights, the DPSP, or none of the above. See, in such a situation, even options like fundamental rights and DPSP may also appear to be very correct way. So it's important to know that these kind of phrases like identity card, key to the Constitution have actually been used with reference to the preamble. So here I have included the basic text of the preamble for you because I highlighted a number of times that the basic text of the preamble is very important for us in order to solve the questions. Now, one thing that I need to emphasize here is that, see, the preamble begins with "We the people of India." Each and every word that has been included in the preamble has been done with a lot of consideration and a lot of thought has gone into doing that. So you may ask, why does the preamble begin with "We the people"? It could have also begun with saying that "We the Constituent Assembly having solemnly resolved." The reason being that the preamble is outrightly telling us that the source of the Constitution of India are the people of India. So this tells us what is the source of the Indian Constitution. Although the Constituent Assembly in India was an indirectly elected body, but the preamble is telling us that the Constituent Assembly as well derives its power from the people of India. And because of this, the Indian Constitution is also the fundamental law of the land because ultimately it is deriving its power from the people of India. So this part of the Constitution where you have "We the people of India having solemnly resolved" is considered as the declarative part of the preamble. This part where we have sovereign, socialist, secular, democratic, these are some of the principles that the Indian state is based on. And these, justice and the trinity of liberty, equality and fraternity, are the objectives that the Indian state is hoping to achieve. So this is the operative part of the Constitution. So we have three parts. We have the declarative part, we have the principles, and we have the objectives and the operative part. See, the reason why it's important for us to know these words as well is because when we watch a lecture or we attend a class, we understand the meaning of the preamble, we understand the meaning of the keywords, but those are being delivered to us not in a technical language. And what happens is, even though we understand at that particular point, when we go to answer questions related to the preamble, where the technical language is used, we fail to answer the question. So it's very important that you also pay attention to the technical words that are being used here. This I already explained to you. What is the source of the Constitution? What is the nature of the Indian state, that is the sovereign, secular, democratic republic, and what are the objectives of the Constitution? Coming to the first word that we have here, sovereign. The basic understanding of sovereign is that India is not a dependency or a dominion, but instead it is an independent state. Also, it was very clearly established that although we are member of the United Nations and the Commonwealth, these are not a limitation on our sovereignty. So a basic understanding of sovereignty we have that we are an independent state and our government is free to decide the internal and external affairs of the country. But it is important for us to know, why is it so crucial that we included the word sovereign in the preamble itself? As I told you, each and every word that has been included in the preamble has a lot of significance. Here I want you to understand what is the opposite meaning what is the opposite word for sovereignty? The opposite word for sovereignty is suzerainty. In the colonial times, India was not a sovereign state. Rather, the British enjoyed suzerainty over India. If you remember the subsidiary alliance, one of the clauses of the subsidiary alliance was that even though the Indian rulers were independent in terms of their internal affairs, the foreign policy or the foreign relations of the rulers remained in the hands of the British. Similarly, if you remember your Government of India Act 1858, one of the provisions written in the Government of India Act 1858 is that doctrine of lapse has been abolished and the Indian rulers are free. However, they continue to remain under the suzerainty of the British Crown. So what is this word that we are talking about? Suzerainty means when a country is not free to decide its foreign policy and determine its international relations. It is another powerful state which has control over the foreign policy of the dependent state. So that is why it is very important for us to understand the importance of sovereignty in our preamble. The reason we are explaining these things is one is so that you do not get confused if you see this word in the prelims related to, say, the subsidiary alliance or the Government of India Act 1858. Also, this kind of a discussion will be very crucial for you, even for your mains, because in 2016 there was a question where it was asked that discuss the adjectives attached to the word republic in the Indian preamble. Now, if a similar kind of question is asked with respect to the word sovereign, do not just confine your discussion to saying what is the meaning of the word sovereignty. But if you also bring in this dimension of distinguishing sovereignty from suzerainty, it will give you an advantage over your peers. The second thing that we will discuss today is the other key word, socialist. So before going to the constitutional interpretation of the word socialist, what do we understand by socialism? As an economic and political doctrine, socialism stands for social ownership of means of production. Every act of production in a socialist framework is viewed as a social product. What do we understand by this? Now, I'm recording this video for you. So, in a capitalist framework, I would say that because I'm recording this video for you and I'm making an effort to record the video and I have acquired the knowledge to present this before you, I have made all this PPT. So whatever is going to be the material benefits out of recording this video should only be available to me. But within the socialist framework, I have to keep in mind that the fact that I am recording the video and the outcome of this is not just merely because of my efforts. There are other people who have assisted me in creating this. There are people with whom I would have discussed the content. There are people who have helped me make this setup. So, the material benefits that would come out of this video should be shared amongst all of us. This is a very small example. We can also broaden our vision. I am able to record this video for you because I have been able to achieve an education. So some social institutions have also helped me. So basically the idea behind socialism is that the product that we have, almost any product that we have, is a social product and the benefits arising out of it should be equally distributed in society. As opposed to capitalism where the belief is on the private ownership of means of production. So socialism in itself is a very broad discussion and we can have a lengthy discussion just on socialism. But for the purpose of understanding what it means in the preamble, this much should be clear to you. Now the word socialism was not present in the original constitution, but it was added as a result of the 42nd Constitutional Amendment Act in 1976. It's important for us to know that What we have in India is democratic socialism as opposed to the communist socialism which is present in countries like China. So what is the difference? In case of communist socialism, there is no belief in a gradual journey towards socialism. The idea is that the objective of socialism has to be attained immediately. And to attain this objective immediately, they often resort to use of force. If you remember your world history, you must have read about the Great Leap Forward of Mao, which was an attempt to convert China from an agricultural economy to a socialist economy with the help of people's communes. And this attempt actually led to the death of a lot of people and brought about miseries to a major section of the population. As opposed to this, democratic socialism is a more gradual journey. And one aspect of democratic socialism is the welfare state that we have. So the socialism that we have in India has been more influenced by the ideas of leaders like Nehru and Gandhi. Socialism also determines how the government decides its expenditure. So you will see that in India we have a lot of social spending. The government spends on various kinds of benefits like old age pension, Manrega. So these are all the features of democratic socialism, where gradually we want to remove the various kinds of inequalities that exist in society. The third principle that we have here is secular. Now, before we understand the constitutional interpretation of secular, let us understand what is meant by the word secular itself. The word secular, just the dictionary meaning of it, is that separation from religion. And if you have gone through your world history, you would have come across this word quite a bit when you discuss the Renaissance, which is the beginning of scientific thinking. So secular also means that we take up a scientific and rational approach. So these are the two dictionary meaning of the word secular. Now coming to how it has been interpreted in the context of the Indian Constitution. Now what we have in India is often described as positive secularism. What is meant by positive secularism? That all religions in our country have the same status and support from the state. Also, let us try and understand how the Indian secularism is different from the Western secularism. Questions related to this have often appeared twice in the UPSC mains. And it's important that we have clarity on this, because if a question comes in the prelims, we should be able to tackle it. See, Western secularism has a clear-cut wall of separation between the state and the religion. But when we talk of Indian secularism, we do not have this clear-cut wall of separation. In fact, in India, the state and religion often interact with each other within certain limited boundaries. To give you an example, up till the 1930s and even till the 1940s, temple entry movements were common in India. And you must have come across various satyagrahas that also happened around the temple entry movement, which was basically for allowing people of lower caste entry into the various Hindu temples. So there is a provision in the fundamental rights itself where it says that the state can throw open Hindu religious institution to classes of all character. So here the Indian state can take certain measures in order to deal with the various kind of social evils that are present. So this is one distinction between Indian and Western secularism. There are other distinctions as well. For instance, in the West, the state will not provide support to any religious educational institution. But in India, the state provides support to minority religious educational institutions. And the religious minorities also enjoy the right to establish their own educational institutions. Also in the West, in Western secularism, the state will not be involved in framing any public policy that impacts religion. But in India, with relation to some special religious endowments like the Waqf board, the state makes some appointments to these boards, and it also makes some policies related to the administration of these boards. So when you are asked a question on Indian versus Western secularism, whether in your prelims or mains, don't just stop at the first point of Western secularism having a clear-cut separation of the state and religion, but also elaborate on these other two dimensions that I discussed. Now coming to the other key word, democracy. Now if you see that there are various ways in which the governments of states have been organized. We have monarchy, we have theocracy. And in the history of evolution of states, if you notice, democracy is the youngest system. However, it has today become the most acceptable system of organizing the government of any state. Within democracy, we have direct democracy and indirect democracy. Indirect democracy is the representative system of democracy that we have in India. And this representative system can be further bifurcated into presidential and the parliamentary system. So what we have in India is a parliamentary democracy. Now coming to direct democracy, there are certain forms of direct democracy. One is referendum. Referendum is when a popular piece of legislation is referred to the opinion of the people. If you recall, an example of referendum was your Brexit, where an important legislation is opened up for voting and the decision of the people is taken with respect to that. That's referendum. Initiative is when the public themselves initiate that they need a particular legislation. Recall. Recall is that the people can recall their representative even before the end of their term in case they are not satisfied with the work that is being done by that particular representative. A good example of this, and recall is especially important for us because the Haryana Assembly has recently passed a Panchayat bill which gives the right to recall. So in this, an office bearer can be called back even before the expiry of his term. And plebiscite, I'm sure that this is a term that you hear most often from Pakistani politicians in reference to Kashmir. So plebiscite is usually used for taking the opinion of the people with respect to deciding certain boundary disputes. And indirect democracy, as I told, is the representative form of democracy where you have the parliamentary and the presidential system. Now, one important thing to keep in mind here is that in India, we are not just talking about political democracy, but as Dr. Ambedkar himself had emphasized, social and economic democracy is very important for a country like India. And this is an important statement that can be easily framed as an MCQ, that social democracy recognizes the trinity of liberty, equality, and fraternity. So these various dimensions of democracy we will discuss in more detail when we move to the discussion on justice because they are quite interrelated. The next key word that we have is republic. Now, to understand the meaning of the word republic, if you remember the movie Super 30, there Hrithik Roshan has a dialogue that अब राजा का बेटा राजा नहीं बनेगा, राजा वही बनेगा जो हकदार होगा. That's basically capturing the essence of republic. Republic is when the head of the state is elected directly or indirectly for a fixed period. However, the meaning of republic does not stop here. Of course, republic is the very opposite of monarchy, where the head of the state is a hereditary ruler. Republic also means vesting of political sovereignty in the people, and there are no privileged classes. That means all kind of public offices, from the position of the President of India to a position of a peon, are going to be open to all the citizens of India. So while we do tend to remember the meaning of republic in terms of the head of the state being directly or indirectly related, these two aspects are something that I want to specially emphasize, because this is something that we tend to forget when we are reading about the meaning of the word republic. Now coming to justice. If you see the text of the preamble, as I keep on mentioning, we have social justice first, then we have economic justice, and then we have political justice. This particular order is actually very important, and this has been done with some thought, because it was felt that political justice, as we discussed about democracy, political democracy, is going to be meaningless if we are not able to attain social justice and economic justice. What is social justice? Social justice is very simple. It means equal treatment, absence of any special privileges, and bringing about improvement in the condition of backward classes. So you know that the principles of social justice have been incorporated in our fundamental rights as well, and this includes the provisions for reservations. So that is related to the idea of social justice. Then we have economic justice. I showed you the prelims questions where economic justice has been asked. So economic justice, the principle of economic justice, we find mostly in the directive principles of state policy. And this is about non-discrimination on economic factors and removing the glaring inequalities. Together, social and economic justice constitute what is known as distributive justice. The third dimension of justice is political justice. We have equal political rights. Everyone in India above the age of 18 years enjoys the right to vote. Equal access to all political office and equal voice in the government. These three ideals of social, economic, and political justice have been taken in the constitution from the Russian Revolution. Liberty. Now here, liberty has two important connotations. One is what we call as negative liberty. Negative liberty is what you have here. That is the absence of restraint. But more importantly, we also have positive liberty. In political science and philosophy, if you read the works of Amartya Sen, then he gives a lot of emphasis on this aspect of positive liberty and freedom in what he calls as the capabilities approach. So liberty here is opportunity for development of individual personalities. See, if we say that, okay, fine, there are no restraint, the state is not going to put any restraint on the liberty of the individual. But at the same time, the state does not make any effort towards improving, say, the status of education in the country. There is no limitation upon you, but also the population is illiterate. So in such a situation, the population of the country will not have the opportunity for development. It cannot develop its personalities. That is why enhancing the capabilities of the people is also an important aspect of liberty. So be very clear about the meaning of these terms so that you do not get tricked in the examination. And of course, we have liberty of thought, expression, belief, faith, and worship. So basically, this aspect is evident in your fundamental rights on freedom of speech and expression, and this part is your freedom of religion. However, liberty in India is not an absolute idea. There are certain important constitutional limitations on liberty that are mentioned in the fundamental rights chapter. Coming to equality. Equality again means the absence of special privileges and providing adequate opportunities for all individuals. There are three ways of understanding equality. One is civic equality, which when we deal with the chapter on fundamental rights, we will see Article 14 to Article 18. Then political equality. Here you know that no one can be declared ineligible for the to be included in the electoral roll on these grounds: religion, race, caste, sex. And elections to the center and the state are held on the basis of adult suffrage. And economic equality. This again, the idea of economic equality, you find it in the preamble as well as you find it in the DPSP, where there are provisions for ensuring adequate means of livelihood, equal pay for equal work. Basically, the whole idea of the welfare state. Next, what we have is fraternity. So here also, I want to emphasize upon one thing, that we know that most of the principles that we see in the preamble have been taken from the objective resolutions. But fraternity is not mentioned in the objective resolution of Nehru. So this can be asked as an MCQ. So please keep this in mind. What does the word fraternity mean? Having a sense of brotherhood. And in India, we have single citizenship. Also, it is mentioned as one of the fundamental duties. In addition to that, there are two other meanings of fraternity. Fraternity also depends on maintaining the dignity of the individual. And one of the fundamental duty also includes that abolition of practices that are derogatory to the dignity of women. Along with that, we also have the unity and integrity of the nation. And the word integrity here was again added by the 42nd Constitutional Amendment. So keep in mind that the 42nd Constitutional Amendment added three words: secular, socialist, and integrity. See, as such, the words secular, socialist, and integrity did not in essence make any change in the Constitution, because these principles were already present in the Indian Constitution in the form of the fundamental rights and the DPSP. But the 42nd Constitutional Amendment just made them more explicit by including them in the preamble. So what is the significance of the preamble? One is it presents before us the vision of the Constituent Assembly. As we already discussed, it is like the philosophy of the Constitution, the soul and key to the Constitution, proper yardstick with which one can measure the worth of the Constitution, lays down the pattern of our political society. See, the reason I have included these points for you here is because, as I told, that it can come in the form of a statement in prelims. And if you see this statement, proper yardstick with which one can measure the worth of the Constitution. If you are given some options here where you have the preamble, the fundamental rights, the DPSP, it will actually be quite confusing because all the options in that exam scenario might appear correct. So these points I have included from Lakshmikant itself so that you know that you should also not skip these parts. Let's come to the next segment where we discuss whether the preamble is a part of the Constitution or not. To understand this, it is important that we make a reference to some of the important Supreme Court judgments. Now, I will give you a brief background of some of the important cases because in the Lakshmikant, these are scattered across different chapters. And once we have a background of the cases, it is also easy for us to interlink and remember them. One thing I want to clarify here, that when we are saying whether the preamble is a part of the Constitution or not, we don't mean in the sense that the Constitution has those 25 parts and whether the preamble is the 26th part of the Constitution. It's not in that sense. Two of the important Supreme Court cases, the most important one is the Berubadi Union case and the Keshavananda Bharti case. So coming to the Berubadi Union case, what was this all about? This was basically related to a boundary issue, and this was about India ceding some of its territory to Pakistan. And this was not a case as such, but it was a precedential reference to the Supreme Court. So what happened in this case is very interesting if you know the background. There was not a controversy, but a kind of opposite interpretation of two words of the preamble. If you see one word of the preamble, we have unity, and we also have one word, that is sovereignty. What happened was the government was ceding a part of what was known as the district of Berubadi Union to Pakistan. So those who opposed the move of the government said that, well, our preamble mentions the word unity. So when the word unity is mentioned in our preamble, how can the government give away a part of the territory of India? However, the other side's argument is that the preamble also mentions the word sovereignty, right? And as we discussed, if you remember, what is the meaning of sovereignty? That a country will have freedom with respect to deciding its internal and external affairs. So when you have freedom in deciding about your foreign policy, you also have the right to cede some of your territory to another country if the government wishes to do so. The Berubari Union case mentioned that the preamble is not a part of the Constitution of India. This was the position of the Supreme Court. Although the court mentioned that the preamble is important for us to get an idea of the minds of the makers of the Constitution, but still it cannot be considered as a part of the Constitution. There were further observations that is more related to the chapter on union and its territory. The second important case, so both the Sajjan Singh and the Golaknath case also made references to the preamble as to whether it is a part of the Constitution or not. The Sajjan Singh and the Golaknath case were related to the 9th schedule and the government putting several land reform acts in the 9th schedule. Here, the Supreme Court did not explicitly overturn the judgment in the Berubari Union case, but there were references that the judgment of the Supreme Court in the Berubari Union case seems misplaced, and it is not correct to say that the preamble is not a part of the Constitution. But most explicitly, the judgment in the opinion of the Supreme Court in the Berubadi Union case was overturned in the Keshavananda Bharti case. So, if you have been following the news, Keshavananda Bharti recently died a few months back. So, basically, he was running a mutt, and this was related to a land reform act of the government of Kerala. And why the Keshavananda Bharti case is important for us? Because it gave us what is known as the basic structure doctrine. Now, one thing to remember is that the Keshavananda Bharti case, the bench of the Supreme Court was a 13-judge bench. It is the largest bench so far. That is why to overturn anything that was said in the Keshavananda Bharti case, even in future, will need an even bigger bench, which has not been constituted so far. So, what happened in the Keshavananda Bharti case is that the Supreme Court overturned the opinion that was given in the Berubari Union case, and it said that the preamble is definitely a part of the Constitution, that the preamble is a part of the Constitution. In addition to this, it made some other important observations. It said that the preamble is to be used for interpretation of the Constitution. So first observation was that the preamble is a part of the Constitution. Second, the preamble is to be used for the interpretation of the Constitution. And another very important observation of the Supreme Court was that the preamble does not give or take away any power. What do we mean by this? That the preamble does not give or take away any power. This is directly related to the answers the question as to whether the preamble is justiciable or not. And if you remember the first question that I showed you, the question was whether the preamble is a part of the Constitution and whether it has legal effect. So the answer to that is that it does not have any independent legal effect unless and until that provision is included in the fundamental rights, then it becomes justiciable. But in itself, the preamble is not justiciable. So other cases also where it was mentioned that the preamble, the opinion of the Supreme Court in the Keshwananda Bharti case was further reinstated in the LIC of India case as well. But with reference to this as to whether the preamble is a part of the constitution or not, the two most important cases being the Berobari Union case and the LIC of India case. So we have answered two important questions here. First is that the preamble is a part of the constitution, and second is that the preamble is non-justiciable. In itself, it does not give us any rights or powers. The second segment that we are going to discuss is whether the preamble can be amended. Now, if you see in the Berobari Union case, the opinion of the Supreme Court was that the preamble is not a part of the constitution. So, because the preamble is not a part of the constitution, it also cannot be amended. However, as we know now that following the Keshwananda Bharti judgment, which I told you as of now was the largest bench constituted, the position has been that the preamble is a part of the constitution, and if the preamble is a part of the constitution, then it can be amended. However, what we also know that the Keshwananda Bharti case gave us the doctrine of basic structure. So, the position currently is that while the preamble can be amended, those provisions of the preamble which are a part of the basic structure cannot be amended. To understand a slightly application-based portion here, if you see, amendment can stand for two things. One, addition, and the other being omitting certain aspects. Now, with respect to omitting, if you notice, most of the key words that are included in the preamble have been declared as a part of the basic structure by the Supreme Court in some of the other judgments. So, like the S.R. Bommai case had declared secularism as a part of the basic structure. So, omitting any part of the preamble as it is present currently does not look likely. Addition, this has been done only once as a result of the 42nd Constitutional Amendment. So, in future, we can expect that there can be certain kind of additions to the preamble that can enrich it further. So, for instance, if the word federalism is added to the preamble because it's not present currently, then it is most likely that this kind of addition to the preamble will not be overturned by the Supreme Court. But omitting any aspect of the preamble is not likely. So, in this respect, we have two cases which dealt with whether the preamble can be amended or not. One we already discussed is the Keshwananda Bharti case. And even the Minerva Mills case, it just reiterated that the preamble, it basically reiterated the importance of the basic structure doctrine. And if the preamble is amended, the basic structure of it should not be touched. So, we discussed three important issues here. One is whether the preamble is a part of the Constitution. The answer to that is yes, it is a part of the Constitution. Because it is a part of the Constitution, it can also be amended. However, the third question is whether the preamble is justiciable or not. The answer to that is that the preamble is not justiciable. It does not provide us with any rights or powers as such. So this is all about the discussion on the preamble. And let's quickly come to the questions that we had. So now we know that it is a part of the Constitution, but it has no legal effect independently of other parts. So for instance, the principles of equality, they have also been included in the fundamental rights. So as a part of the fundamental rights, they are justiciable, but not as a part of the preamble. So here our answer is going to be D. Here the separation of judiciary from executive is enjoined by, we went through the entire text of the preamble and we know that it is definitely not present in the preamble. So we know that it's part of the DPSP. This question you will be able to answer once you have clearly studied the DPSP and the fundamental duties as well. But for now, the answer for this is D. Economic justice as the objective of the Constitution has been provided in. So we saw that it is present in the preamble and it is also a part of a PSP. It is not a part of the fundamental rights. So this will be our answer. So guys, that's all from my end today. I hope that you enjoyed the discussion on the preamble and you learned from it. And I have made an attempt to highlight those segments of polity from Lakshmikant that you should not skip, because when we are studying, they appear very obvious to us, but we should not skip those parts where the significance of the preamble is written or where the introduction to the preamble is written in your book. See, as I already mentioned, that when we explain these issues or when you watch a class, you feel that you have understood what is the topic all about. But in the exam, we often find it difficult to answer the questions. The reason being that the exam employs a slightly more technical language. Because of that, please supplement these lectures with one of the standard textbooks so that you are also aware of the technical language and the constitutional language that can be used so that you can easily answer any question in the exam. Okay, that's all from my side, guys. All the best. Thank you.